The first well went dry on a Monday in early July. A family 2 streets over waking up to nothing but air sputtering through their kitchen tap. And by that Friday, 87 households across Hollow Creek Ranch, every single home relying on the community's shared aquifer system rather than municipal water, had experienced the exact same failure. A cascading crisis that took me nearly 2 full weeks to trace back to its actual cause. A cause that had nothing to do with drought, equipment failure, or any of the explanations our HOA board initially offered, and everything to do with a private mineral and water rights sale that Priscilla Ashworth Vandermeer had quietly authorized nearly a year earlier. My name is Rosalind Aikben-Kemalu. I live in Hollow Creek Ranch, a community of about 90 homes built on large, semi-rural acreage lots, developed specifically around shared access to a substantial natural aquifer that had, for the 17 years since the community's founding, provided reliable, high-quality water to every household through a series of community-owned wells and a shared distribution system, an arrangement that had functioned so smoothly and unremarkably for so long that most residents, myself included, gave it about as much thought as any homeowner gives to municipal water service, which is to say almost none at all, until the day it simply stopped working. I want to walk you through those first confused days, because none of us initially understood we were dealing with anything beyond an unfortunate, if serious, mechanical or environmental problem. The HOA's initial communication, sent once enough households had reported dry wells that the pattern became impossible to ignore, described the situation as resulting from unprecedented regional aquifer stress, possibly related to drought conditions, a plausible enough explanation on its face, since our region had, admittedly, experienced a somewhat drier than average spring. I want to introduce you to my neighbor, a retired hydrogeologist named Bartholomew Ferrer de Lacroix, who had actually worked professionally on aquifer management projects for over 3 decades before retiring to Hollow Creek Ranch, specifically because of its rural character and reliance on exactly the kind of natural water system he'd spent his career studying. Bartholomew, upon hearing the HOA's drought explanation, told me directly, within our first conversation about the crisis, that something about the timeline and pattern of the well failures struck him as inconsistent with genuine drought-driven aquifer depletion. Rosalind, he said, drought-related aquifer stress typically shows a gradual decline pattern, wells producing progressively less water over weeks or months as the water table slowly drops. What's happening here? 87 wells failing within a single week, nearly simultaneously, is not how natural aquifer depletion actually behaves. This looks considerably more like something happened to the aquifer's actual structural access, not simply its water volume. I want to walk you through the investigation Bartholomew and I undertook together over the following week, because his professional background made this considerably more productive than it might otherwise have been. He requested access to the community's well monitoring data, historical records the HOA maintained tracking water table depth and well output over the preceding years. And what he found, once he'd reviewed the data alongside the specific timeline of the failures, confirmed his initial suspicion. The water table itself, according to the monitoring data, had not actually dropped anywhere near enough to explain a complete well failure across the entire community. Something else had happened to disrupt the well's actual physical access to the aquifer. I want to introduce you to the piece of information that finally cracked this case open, because it came from an unexpected direction. A resident named Farrokh Okonkwo Whitfield, who worked in commercial real estate and had, as part of his professional routine, a habit of periodically checking county property and mineral rights records for various reasons related to his own work, mentioned, almost in passing during a neighborhood gathering discussing the ongoing water crisis, that he'd noticed something unusual while doing an unrelated records search a few months earlier. A filing showing that the mineral and water rights beneath a significant portion of Hollow Creek Ranch's land, rights that most of us had always assumed remained bundled with the community's own common area ownership, had been sold to a private extraction company roughly 10 months earlier. I want to sit with that detail for a moment, because it took Bartholomew, Farrock, and me a genuinely stunned few minutes to fully process what this actually meant. Someone, at some point 10 months earlier, had sold the underlying water rights to our own community's aquifer, the exact water source 87 households depended on entirely, to an outside company, and none of us had ever heard a single word about it. I pulled the actual recorded sale documentation from the county the following day, and what it showed, once I finally had the complete picture in front of me, was that the sale had been executed by Priscilla Ashworth Vandermeer, in her official capacity as HOA board president, transferring the community's water and mineral rights to an entity called Ridgeline Resource Holdings, for a sum of just over $200,000, a transaction that, as far as any of us could determine, had never been brought to the full membership for a vote, never been announced through any community newsletter, and never been disclosed to a single resident outside. Apparently, whatever small circle within the board had approved it. I want to walk you through what happened next in the actual wells themselves, because Bartholomew's professional assessment, once he understood the sale had occurred, clarified the mechanical cause immediately. Ridgeline Resource Holdings, having legally acquired the underlying water rights, had apparently begun their own extraction operations on the aquifer roughly 2 weeks before our wells started failing. Operations that, given the aquifer's specific geological structure, had disrupted the pressure and flow patterns our community's own wells depended on, effectively drawing down the shared water source faster and more disruptively than our own more modest residential usage ever had. "This is not a coincidence," Bartholomew told me, once he'd finished reviewing everything. "Ridgeline's extraction activity, now that they legally hold the rights to draw from this aquifer at industrial volume, is directly responsible for the pressure disruption causing your community's wells to fail. And I want you to understand something important here, because it matters enormously for what happens next. Once someone else holds the legal water rights beneath your land, your own wells essentially become subordinate to their extraction activity. You don't have any automatic legal claim to continued access, regardless of how long your community has relied on that water, unless the original sale itself can be successfully challenged. I want to tell you about the moment I understood the true scope of what Priscilla had actually done, because it went well beyond a simple bad decision or an unfortunate oversight. She had sold the literal water beneath 87 homes, quietly, without any membership vote or disclosure, to a private company that was now legally entitled to draw from that same aquifer at whatever volume their extraction operation required, leaving our entire community's water supply subordinate to a for-profit resource extraction business that had no obligation whatsoever to consider our household's needs. That's where part 2 picks up, because what an attorney I contacted that same week discovered about exactly how Priscilla had authorized this sale, and about a specific provision buried in our own governing declaration that neither she nor, apparently, Ridgeline Resource Holdings' own legal team had ever properly accounted for, is the reason this story ends not with 87 families permanently losing their water, but with the entire sale voided, the aquifer rights restored to community ownership, and Priscilla Ashworth Vandermeer facing considerably more serious consequences than simply losing her board seat. I called an attorney within days of confirming the sale, a woman named Adiz Kowalska-Ferrara, who specialized in HOA governance and natural resource disputes, a specialty considerably narrower and more specific than most attorneys practice, and one that turned out to be exactly what this genuinely unusual situation required. Adiz reviewed the sale documentation, the county filing, and our community's own governing declaration, and told me within our first meeting that she believed we had a strong basis to challenge the entire transaction. "Rosalind," she said, "most HOA governing declarations include specific provisions addressing the disposition of shared community resources, and given how central this aquifer clearly was to your entire community's founding purpose, I'd expect Hollow Creek Ranch's declaration to include exactly that kind of protection. Let's find out exactly what it actually says." I want to walk you through what Adiz found, because it turned out to be precisely the leverage we needed. Buried in Hollow Creek Ranch's original governing declaration, filed when the community was first developed 17 years earlier, was an explicit provision requiring any sale, transfer, or disposition of the community's shared water rights or aquifer access to be approved by a supermajority vote of the full membership, with specific advance notice requirements detailing the proposed transaction's terms. A provision clearly written by the community's original developer, specifically because the entire development's viability depended so completely on reliable shared aquifer access. Precisely the kind of foundational resource protection that made this declaration considerably more explicit on this particular point than most standard HOA governing documents typically are. No such membership vote had ever occurred. No such advance notice had ever been sent. Priscilla had executed the entire sale unilaterally, in direct violation of her own community's explicit governing document requirements, a violation that Adiz explained gave us a genuinely strong basis to challenge the sale's fundamental validity, not simply as an unwise or poorly communicated decision, but as a transaction that had never been legally authorized in the first place. Adiz filed a formal legal action seeking to void the aquifer rights sale entirely, based on the clear declaration violation, and simultaneously filed for emergency relief given the genuine, ongoing crisis of 87 households currently without functioning water access. I want to walk you through the specific urgency of that emergency filing, because by the time this litigation began, several affected families had already been without reliable water for over 2 weeks, relying on bottled water deliveries and, in a few cases, temporary relocation to relatives' homes, a genuinely serious hardship that Adiz argued forcefully warranted expedited court attention. The court granted an emergency temporary order within days, requiring Ridgeline Resource Holdings to immediately suspend all extraction activity on the disputed aquifer pending full resolution of the underlying sale's validity, an order that, once implemented, allowed the aquifer's natural pressure and flow patterns to begin recovering, and within about a week, the majority of the affected wells had returned to at least partial functionality, though full restoration to normal pre-crisis output took considerably longer. I want to walk you through how the underlying legal challenge to the sale itself ultimately resolved, because it moved through the court system over the following several months, complicated by the fact that Ridgeline Resource Holdings, having purchased the rights believing them to be legitimately and properly authorized, had its own legal interest in defending the transaction's validity. Facing the clear, unambiguous declaration language requiring membership approval that had simply never occurred, Ridgeline's own legal team ultimately concluded that continuing to defend the sale carried substantial risk, and the parties reached a settlement in which the water and mineral rights were formally and permanently transferred back to full community ownership, with Ridgeline receiving a partial refund of their original purchase price from funds Priscilla personally. And separately, the HOA's insurance coverage were required to contribute given the clear governance violation underlying the original improper sale. I want to tell you about how Priscilla had actually managed to execute this sale without any membership awareness at all, because it mattered enormously for the community's broader reckoning with what had happened. Discovery in the litigation revealed that Priscilla had characterized the transaction, in the limited internal board communications that did exist, as a resource optimization licensing arrangement, deliberately vague language that appeared designed to obscure the transaction's true nature even from her own fellow board members, several of whom, once the full sale documentation became public through the litigation, stated clearly that they had never understood they were approving an outright sale of the community's core water rights, believing instead they were authorizing some kind of limited, reversible licensing agreement. I want to walk you through the community meeting that followed. Once the full scope of what had actually happened became clear to the broader membership, because it was, understandably, one of the more emotionally charged gatherings Hollow Creek Ranch had ever held, residents who had spent weeks without reliable water, some having incurred real financial hardship from bottled water costs and temporary relocation expenses, finally understanding that this entire crisis traced back to a single unilateral, deliberately obscured decision made nearly a year earlier. Priscilla, given the opportunity to explain herself at that meeting, offered an account that satisfied almost nobody in the room, characterizing the transaction as an attempt to generate supplemental community revenue that she'd believed, at the time, would not meaningfully impact residential water access. An explanation that a man near the front, one of the families who'd lost water access for nearly 3 full weeks, responded to directly. "You sold water that 87 families depend on to survive," he said, "without telling a single one of us, and you're telling us you thought this wouldn't affect our water access. What did you think water rights meant?" The vote to remove Priscilla from the board was immediate and unanimous, and the community additionally pursued a separate legal claim against her personally, seeking to recover the financial hardship costs affected families had incurred during the weeks of water crisis. A claim that, combined with the underlying governance violation already established through the sale challenge, resulted in a settlement requiring Priscilla to personally contribute meaningful compensation to the affected households. Alongside the portion of the ridgeline refund her own insurance, and personal assets were required to cover. I want to tell you about the day the aquifer rights were formally and permanently restored to community ownership, recorded with the county, with an additional protective provision ADs specifically negotiated, requiring any future disposition of the community's water rights to undergo not just the existing supermajority vote, but a mandatory independent hydrogeological review, and a minimum 90-day public comment period before any board could even bring such a proposal to a vote at all. A safeguard designed specifically to prevent any future board president from ever again quietly executing a transaction this fundamental to the community's basic survival without full, informed membership awareness. I want to tell you about the wells now, because they've returned to full, reliable function, the aquifer's natural pressure and flow patterns having fully recovered in the months since Ridgeline's extraction activity ceased entirely. I remember standing in my own kitchen, running the tap simply to watch clean, steady water flow the way it always had before any of this happened, feeling a specific kind of gratitude for something so basic that none of us had ever thought to actually appreciate until we spent 3 weeks without it. If there's a lesson in this story, I think it's something Bartholomew said to me during one of our early conversations, back before we'd even confirmed the sale had actually happened, simply trying to understand why our wells had failed so suddenly and completely. He said that the resources communities depend on most fundamentally, water chief among them, are often exactly the ones residents think about least, precisely because they've simply always worked reliably. A quiet trust that makes exactly this kind of unilateral, deliberately obscured decision possible, since nobody thinks to specifically watch over the one thing they've never had reason to doubt. We started watching, and it turns out that one retired hydrogeologist's professional instinct that something didn't add up, one neighbor's habitual property records check that happened to catch an unusual filing, and one explicit 17-year-old declaration provision that Priscilla had simply hoped nobody would bother to read closely were more than enough to bring the water back to all 87 families. And to make sure nobody ever again got to sell what an entire community actually needed to survive without every single household knowing about it first. Thumbnail text: SHE sold our water without telling US.